My name is Lee Ern, and this is the video assignment for the Equity and Trust 1 module. In this question, we are faced with a situation concerning two wills made by Anthony, who is now deceased. He is survived by Stella, his wife, who he had married in 2020. They were in the midst of divorce proceedings before his death. Stella also gave birth to a daughter, Georgina. Anthony had drafted two wills, one in 2018, hereinafter referred to as the 2018 will, and a new one in 2024, the 2024 will. In both wills, David was appointed as the sole executor. After a person dies, their estate, which refers to all the immovable and immovable property they owned during their lifetime, can be distributed to existing beneficiaries through administration of the estate. Authorization of the courts in the form of grant of representation is required for such administration. The type of grant will differ when the deceased dies testate or intestate. The deceased dies testate if he dies with a valid will, which is a declaration intending to have legal effect of the intentions of a testator with respect to his property and other matters which he desires to be carried into effect after death, drafted and executed in accordance with the law. The courts will grant probate, which is a legal authorization of the court to the executor if they find the will to be valid. The effect of grant of probate is 1. It confirms the executor's authority to act in accordance to the will. 2. It is confirmation by the courts that the will is properly executed and represents the final testamentary intention of the deceased. However, if the deceased dies without a valid will, he dies intestate, and his estate shall be distributed in accordance to Section 6 of the Distribution Act 1958, except when his estate falls into the description of a small estate, then it is distributed according to the Small Estate Distribution Act. In West Malaysia, the Civil High Court has the jurisdiction to grant probates by virtue of Section 24, Paragraph F of the Courts of Judicature Act. Therefore, we will examine the wills on its own and identify what grounds may be raised by the parties involved to contest the will's validity and/or admissibility to probate, to determine whether Anthony had died testate or intestate. Starting with the 2024 will, as it is executed most recently, it presumably is the testator's last will and testament. The legal requirements for a legally valid will includes the following. 1. The testator must be of the age of majority, which is 18 and above according to Section 2 of the Age of Majority Act 1971. 2. The testator must have the intention to make a will. 3. The testator must have testamentary capacity. This is a question of fact on whether the deceased, at the time of execution of the will, or at the time of giving instructions, is of sound mind, memory, and understanding. 4. The testator had exercised free will when making the will. 5. The will is duly executed in compliance with the required formalities listed down in Section 5 of the Wills Act. In short, the requirements are that A. The will must be in writing. B. The will is signed by the testator in the joint presence of two or more witnesses. And 3. The will must be subscribed by the witnesses in the presence of the testator. The will's validity can be contested during probate proceedings on the grounds that any of the previously mentioned rules are not complied with. From the facts of this case, the validity of the 2024 will can be challenged on the ground that the will was not duly executed. When executing the will, the testator, Anthony, left before Ed and Fred, the witnesses, could sign the will. Section 5 clearly states that witnesses must subscribe to the will in the presence of the testator. The test of being in presence, as held in Carter and Seaton, is whether or not the testator could have seen the signatures if he wished to do so. Anthony had already left the scene and rushed over to the hospital when Ed and Fred signed, so it is clear that Anthony could not have seen the witnesses sign the will, rendering the will invalid for being unduly executed. Hence, the 2024 will is invalid. With that, the court will fall back on the 2018 will, which was executed earlier. Probate can be granted to an earlier will in the case where the later will is invalid, as seen in the case of Ko Cheng Pop and Ko Cheng Pun. To determine whether the 2018 will can be admitted to probate, we must see if 1. The will is valid, and 2. Whether or not the will has been revoked. As earlier mentioned, the non-compliance of required formalities in the execution of the will renders the will void. From the case facts given, the will was executed after Anthony turned 21, so he is of the age of majority. On due execution, Anthony had signed the will in the joint presence of both Bob and Charlie, the witnesses. Bob subscribed to the will in the presence of both Anthony and Charlie. However, Charlie only signed on the next day and in the presence of Anthony only. This fact may be raised to challenge the validity of the will. But applying the case of Dr. Shanmuganathan and Periya Asami, there is no requirement for the witnesses to sign the will in each other's presence. It is sufficient if subscription is made with only the testator and the individual witness. Hence, the 2018 will has been validly executed. The next issue is whether the 2018 will had been revoked. It is a general rule in probate law that a later will does not automatically revoke an earlier one, as held in the early English case of Lemage and Goodman. Therefore, the law provides for how revocation is effected in Sections 12 and Sections 14 of the Wills Act. There are 4 methods, and it can be further categorized into voluntary or involuntary methods. There are 3 voluntary methods provided for under Section 14 and existing case law. For voluntary revocation, there must be the act of revocation with the required intention to revoke subsisting at the same time. The first voluntary method is express revocation in a new validly executed will, codicil, or any writing declaring such intention, which is also executed in the manner required of a valid will. The second method is by implied revocation, wherein the earlier will is either wholly or partially revoked based on the extent of inconsistencies between the later will and the earlier will. Intention to revoke is inferred from the inconsistent dispositions. Finally, the third voluntary method is revocation by destruction of the will, by burning, tearing, or otherwise destroying by the testator, or by some person directed by the testator with the act of destruction done in the testator's presence and instructions. The testator must have the intention to revoke the will when performing the act of destruction, and this is inferred from the surrounding circumstances. Meanwhile, the involuntary revocation method under Section 12 automatically revokes a will upon marriage, unless that will was made in contemplation of marriage with a particular person, as held in the cases of Salas and Jones and Pilot and Gainford. Looking at the facts of the case, multiple issues are raised which can argue that the 2018 will is revoked. The first issue lies in the inconsistencies between the 2024 will and the 2018 will, and whether the 2018 will is impliedly revoked by the 2024 will. Comparing the terms in both wills, there is a complete inconsistency between the dispositions, as the 2024 will bequeaths all property to David, while the 2018 will bequeaths all property to Bob, Charlie, and his future wife equally. Applying the principle from Ree Palmer's Goods, when there is total inconsistency between 2 wills, the earlier will is impliedly revoked. However, Section 14 also states that to revoke a will with another, that new will must be validly executed. As we discussed earlier, the 2024 will is invalid for not complying with required formalities. Hence, since the 2024 will is invalid, there is no implied revocation of the 2018 will. The second issue is whether the 2018 will is destroyed and whether such destruction had revoked it. During a quarrel, Stella had teared the will and flushed it down the toilet. The will was not destroyed by Anthony personally, and since there was a quarrel between them, it can be reasonably argued that Stella's actions of tearing and flushing the will was made in her own fit of anger, not by the direction of Anthony. The case of Gill and Gill can be applied here, as the case facts are similar. The act of destruction was not done by Anthony, nor done by Stella at his instructions, so the 2018 will is not revoked by destruction. The third and final issue in relation to revocation is whether the 2018 will is automatically revoked due to Anthony's marriage to Stella. Anthony and Stella were married in 2020, 2 years after the valid execution of the 2018 will. Anthony and Stella have not met at the time the 2018 will was executed, so that disposition for his future wife was clearly not made in contemplation of marriage with Stella in mind. Hence, applying the principle in Pilot and Gainford, the 2018 will is automatically revoked upon marriage. In conclusion, the 2024 will is invalid and the 2018 will has been revoked. Anthony died intestate. Therefore, Anthony's estate will be distributed in accordance to the rules of intestacy as provided in Section 6 of the Distribution Act. Unless his estate falls into the description of a small estate, then it shall be distributed in accordance with that act. Both acts are applicable since Anthony was domiciled in the West Malaysia up to the time of his death. The following issue then arises on whether Stella is regarded as a surviving spouse entitled to the estate, or to put more simply, were Stella and Anthony still married at the time of Anthony's death? This answer will also affect the determination on whether Georgina can be regarded as Anthony's child under the Distribution Act, as Anthony and Stella's marriage status may affect her legitimacy. In Malaysia, non-Muslim marriages are governed by the Law Reform Marriage and Divorce Act 1976. Any marriage solemnized and registered in accordance to this act is valid and legal and only terminates upon a decree absolute issued by the courts. Furthermore, cases such as Hulse & Taverner, Sinclair and Fell have propounded the general principle that legal marriages are only dissolved upon a decree of divorce absolute. In this case, the divorce between Anthony and Stella has not yet been finalized, since it is stated in the facts that the divorce proceedings are still in process. Therefore, in law, Anthony and Stella are still legally married up till Anthony's untimely death. With the marriage status issue answered in the affirmative, Georgina, who was born within this period, is Anthony's legitimate child. Additionally, the facts also expressly states that Georgina was conceived before divorce proceedings. Therefore, both Stella and Georgina are qualified beneficiaries. Assuming that Anthony does not have surviving parents, his estate will be distributed in accordance with Section 6 paragraph E of the Distribution Act, wherein Stella is entitled to 1/3 of the estate and Georgina to 2/3. Now, we will look at the alternative circumstances where in the unlikely situation where the court finds either 1. the 2024 will valid, or 2. that the 2018 will is not revoked, Anthony will have died testate. Probate will be granted to the executor named therein, which is David in both cases, to distribute the estate in compliance with Anthony's intentions. In the first circumstance, where the 2024 will is valid, it impliedly revokes the 2018 will due to the total inconsistency of dispositions. There is only a sole beneficiary named, which is David. The executor may also be a beneficiary, so David will inherit the entirety of Anthony's estate. In this situation, Stella is entitled to apply for a maintenance order under the Inheritance Family Provisions Act 1971. As previously discussed, Stella is still married to Anthony up till his death, and Georgina is Anthony's minor daughter. Both qualify as dependents described under Section 3, subsection 1 of the Act. Stella can make an application to court on behalf of herself and Georgina for a maintenance order within 6 months from the date an application for probate has been made. The courts will take into account several factors, such as the past, present, or future capital or income of the dependent, the conduct of the dependent in relation to the deceased, the reasons for the deceased dispositions made in the will, and other factors listed out in Section 3 of the Act to determine whether an order should be granted and the extent of maintenance amount. However, due to insufficient facts, it cannot be ascertained whether or not a maintenance order will be granted to Stella. In the second circumstance, where the 2018 will is found to not be revoked and the 2024 will invalid, probate will be granted to the 2018 will. However, the bequeathed gifts to Bob and Charlie are void pursuant to Section 9 of the Wills Act, as they are also the witnesses to that will. As for the beneficiary only described as my future wife, it is a general rule of construction that the courts will strive to read into the intentions of the testator. As Stella was indeed Anthony's future wife, in comparison to the time that the will was drafted, it is highly likely that the courts will accept this interpretation of disposition. As for the residuary estate from Bob and Charlie's void gift, it shall be distributed in accordance with the rules of intestacy, since it is a partial intestacy due to the lack of a residuary clause. In conclusion, based on the facts, Anthony has most probably died intestate, as the 2024 will is invalid and the 2018 will is revoked. His estate will be distributed according to the law of intestacy, where Stella and Georgina will be entitled to his estate. But when alternative circumstances arise, further legal issues involved in distribution of Anthony's estate will include voided gifts, applications for maintenance orders, and the rules of construction of the wills. This concludes my presentation. Thank you.